Everything was burned in the backyard. My name was forged to get the payoff and the information.
You just lied to the court. You just lied to the court.
No, I did not know.
You signed this, Miss Ainley.
didn't.
We'll go on the record in the matter 22 FA 45, in re the marriage of Timothy Ainley and Rachel Ainley. Appearances are we have both parties appearing in person without counsel. We're set here today in this matter for a contempt hearing. We were here previously on November 8th, 2024, in which we had...
Before we even get started, understand this. This is not just a messy divorce. This is a contempt hearing, which means someone is already on the judge's last nerve. Contempt is court speak for, you ignored a direct order, and judges take that personally. When emotions, property, and credibility collide like this, somebody's about to lose big, either money, freedom, or both. Watch closely who the judge believes, because belief is everything in a case like this.
A little bit of a hearing, and the parties were instructed to bring all evidence and information for the court to present here today. At the last hearing, Ms. Ainley informed the court that she was prepared to proceed with an accepted offer of the house for November 22nd for tomorrow to sell the house. And she needed Mr. Ainley to sign off on everything. And that's why the court scheduled the final hearing for today. Mr. Ainley, this is your contempt hearing. And so you have the burden of proof. I'm going to have both parties stand, raise your right hands, be sworn in. Mr. Ainley, at the previous hearing, you had indicated that there was a list of property that you stated that you had left at the marital residence, and that either was just left there and you had not yet received, or that Ms. Ainley had destroyed and that you wanted compensation for, and you were going to inform the court of that property and of the value that you were seeking.
This moment is huge. The judge just made it clear. The burden of proof is on him. That means he doesn't just complain. He has to prove what was destroyed, what was taken, and why he deserves compensation. No proof, no payout. Courts don't run on vibes or emotions. They run on evidence, documentation, and consistency.
You may begin with your testimony.
Yes, ma'am. After the divorce was final, we came to an agreement that day on everything that was supposed to be surrendered to me. And she agreed on that. Well, being that there was a restraining order or no contact order in place, I had to come to court and get a court date set. It was signed by Commissioner Krupa for 2 days on a Friday and on a Saturday and Sunday to go retrieve my property. And the agreement was she was not to be on the property or on the property when she was supposed to have everything staged in the driveway with all my personal property. And I went out that day, and some of the items were out in the driveway, and I pulled in, started getting stuff. Here she comes. She had her boyfriend or whatever, fiance, whatever, it doesn't matter, but she was there, and I automatically just had an anxiety attack. So I just got what was in the driveway, left, and therefore I couldn't go back the next day because, I mean, she was there, and that was, that was a violation, really. I couldn't go back. She was there. And to my knowledge, she refused to.
Here's where legal reality crashes into human emotion. A restraining order isn't flexible. Anxiety, fear, even panic attacks don't override court orders. If she was there when she wasn't supposed to be, that's not just disrespect, that's potential contempt. And judges don't guess. They check timestamps, orders, and written instructions.
Let me go to the property while she is not there and not have access to anything that was in the home or my personal belongings or my four-wheelers and everything like that, and my pontoon, my chainsaw. I had I got a list here of stuff that was, and I did retrieve a few things, and what was there was damaged and beyond repair. I mean, it was destroyed. The hole drilled through the block of the four-wheeler, the lawnmower. I mean, everything I had was just what I got. We did retrieve that was in the driveway was totally destroyed. And the order from Commissioner Krupa that she was not supposed to be there. She was, I mean, that was just a setup for me to go back to jail again for violating an order of protection.
At the hearing on September 28th, 2023, did you provide a list of that property to the commissioner or to the court of what you wanted to retrieve?
That list was already included with our divorce hearing. All of my personal tools, all of my personal property, the furniture in the basement.
First, Ms. Hess, formerly known as Ms. Ainley, were you at the property when Mr. Ainley went to retrieve his?
I was in the house, yes.
Why were you at the property?
I had nowhere to go. And I had to get his stuff out.
You were specifically told at the hearing with Commissioner Krupa on September 28th, 2023, that you were not to be anywhere on that physical property.
I didn't have a choice.
You did have a choice because Commissioner Krupa said not to be on that physical property, not to be on that residence at all.
I didn't have no idea what time he was supposed to even be coming.
It
Was I supposed to
says,
stay gone all day?
you did know, and I can tell you right now, you did know because it says pickup times, September 30th, 2023, between 2 p.m. and 4 p.m. and October 1st, 2023, between 2 p.m. and 4 p.m. So you knew exactly when he was going to be there. Exactly.
Leaving his stuff out there. He's
No.
already saying it was damaged.
You just lied to the court. You just lied to
No,
the
I
court.
did not know.
You did know. You did know. That's
He didn't
physically.
show up. No, he did not show up when he was supposed to. There was time set in June for him to come. He didn't show. I didn't know if he was going to show or not. I wasn't going to take a chance of leaving his stuff sitting out there.
Mr. Ainley,
Your Honor, if it need be, I've got two witnesses that came with me with two trailers to load my personal property up. Her and her ex-fiance was out there. Her middle son Dylan was out there. They were all out there. She walked up and down the driveway following me, trying to talk to me. So that's all I got to say. She was there. She knew the date. She knew the time. I was there about 10 minutes after I think it was I really can't recall the exact time on the
Mr. Ainley,
clock.
I believe she knew the date. I believe she knew the time. She just lied to the court.
Yes,
I do
ma'am.
not find her credible at all.
Yes, ma'am.
Continue.
That sentence right there, I do not find her credible at all, is devastating. In court, credibility is currency. Once the judge stops believing you, everything else you say gets discounted. It doesn't matter how emotional, how loud, or how confident you sound. If the judge thinks you're lying, your case is already bleeding out.
All right, this is a list of my personal property. All my clothing, all my suits, my dress slacks, everything from hunting, winter, everything was burned in the backyard. It was told, my children told me that.
You can't tell me what your children have told you.
Journey, my 9-year-old, and my 12-year-old said that.
You can't tell me what they've told you.
Okay, so what are you asking then?
I'm asking what property you have not received and what you're asking as reimbursement for that property. Ms. Ainley, what would you like to say?
All of his belongings that he did leave are at the house. I haven't touched anything.
But
His
I don't,
generator.
but here's the thing. Again, I fully instructed both of you. And I'm gonna guess you don't have pictures or documentation of their condition.
No.
And
it's
so
the same
I'm
way
gonna
he
take
left it.
testimony from both of you. And so far I found you not credible.
All of anything and everything that I needed to live an everyday life was gone. Everything on this list, I never received this, except I did receive the pontoon boat.
All right, so Ms. Hess, you have a copy of all of these items that he is requesting. Are all of these items at the home?
No,
Why not?
because he took some of them.
He's indicating he did not. All right, now
this-
what else are you asking for?
Okay, I'm also asking for reimbursement of all of the reinstatement fees that I've had to pay for the mortgage payments and legal fees. The property was really close to being foreclosed on. I mean, within days, and I wasn't aware of this. The mortgage is just in my name because Rachel couldn't have her name on anything. She had so many judgments against her. So it's just in my name. The mortgage is through Cross Country Mortgage. I've got a reinstatement amount here that is paid. It's $10,059.40. That is current. And
you're saying that you paid this amount to keep it from going into foreclosure?
not the total amount, no ma'am. Part of it went on the back of the loan. I have copies of the payoffs here, 3 copies. And with the legal fees that I had tacked on here, that's going on the loan that I don't feel that I should be responsible for because I pulled it out of foreclosure and I've been making the payments for the last probably 7 or 8 months. I've got everything here.
Which are what?
I've got my bank statement payments where I've made the payments on
Exhibit 5, your bank statements. Yes, that's what you're asking for?
yes, ma'am. And then this is copies of the payoff. I mean, it shows I've got 3 copies of this also. It's going to be needed here in a few minutes.
What I'm looking at.
This is, okay, I'm going to kind of jump back and forth just a little bit here on the reason I received this. I've received 5 letters in the mail from mortgage companies and lending companies stating what the payoff is, where they requested payoffs on the loan. And my loan and mortgage information was all sealed. No one had access to it at all because my ex-wife here tried to get in to find out a payoff on it about 6 months ago. And they told her, no, you can't. Tim's going to have to get that for you. So anyways, I got 5 letters in the mail from 5 different loan companies and a title company stating that someone requested the payoff. So I got a letter from 5 different companies for people that requested the payoff and they sent it to them. So I called them yesterday and to find out why. And they said, well, you signed a release form on November the 5th of this month to release information for your payoff. I said, no, ma'am, I did not. And I said, ask her if she could email that to me. She said, yes. So she emailed it to me and my name has been forged on this paper. It is not my signature. And the owner is not Rachel Ainley as far as the loan goes, what's on the loan mortgage papers. So she forged my name on this paper to get the payoffs on my personal information.
Who did?
Ainley, please be quiet.
My ex-wife has signed my name multiple times when we were married. I give her permission to do that when we were married. Nobody else knows my social security number but her. She knows it by heart. And on the November the 5th this year, she signed my name for release of my personal information on my banking information. It's I'm pretty upset about this. I mean, it's like a total breach of my confidentiality and everything else in my personal business. The lady called me yesterday from a title company. Let me get I'm just nervous. A lady called me yesterday from a title company. She said, Mr. Ainley, we have a check for dividends for the sale of your property on North Boston Road. I said, a check for what? She said, well, we're closing on that on the 23rd. I said, absolutely not. This is in legal issues right now. I said, no. I said, I'm not getting a check. So anyways, I told her my name was forged to get the payoff and the information on this mortgage. And so she didn't say anything else. She hung up. But In the meantime, I mean, the house, I've got a paper here from, Leon from Grasswood Realty, where she refused a $197,000 offer a few months back.
And that is exhibit number 3.
This is not my signature.
And it looks like Timothy Ainley on 11/5/24, and then it's Rachel Ainley on 11/5/24 with social security numbers. That is not your signature.
No, ma'am.
You did not sign that authorization to obtain information.
Absolutely not. This was signed 3 days before we had our court hearing on the 8th of this month when you postponed the court date to today.
I'm going to tell you that I'm looking at the dates and the social security numbers as they are written, and they look exactly like they're written by Miss Ainley. The dates and the social security numbers as written, the 8s are identical. I'm not a handwriting expert, not one who has went to school, but I'm going to tell you just by looking at it, Miss Ainley, I'm going to tell you, you did this.
No, ma'am.
Oh, yes, ma'am.
Where would I have signed it? I haven't been anywhere to sign anything.
Your name is signed on this.
I'm not
These
Rachel
eights are
Ainley.
stop talking over me. You did this, Miss Ainley. You signed this, Miss
I
Ainley. You signed this.
No, I
You
didn't.
did this.
No, ma'am. I promise you I didn't.
Oh, you can promise all you want. You are not credible.
Okay.
You did this.
Okay.
These 8s are the same. This 11/5/24 dates are the same.
They're not though.
They're the same.
You can call Katie. I'm not the one that signed.
I can call Katie.
Yes, ma'am. I did not sign.
You didn't sign in front of Katie.
I didn't sign at all.
This is no longer family court drama, this just crossed into criminal law. Forging a signature on mortgage or financial documents isn't just shady, it's felony-level fraud. That's why the judge's tone changes here. Divorce disputes can cost money, fraud can cost freedom.
Oh, so somebody forged your name
Ma'am,
too?
I have not signed anything. I was supposed to sign with the title company on Wednesday and I didn't.
Oh, so I have 2 fraudulent transactions here. Somebody forged your name, your
Yes, ma'am.
social security number and yours. That's good. I need to let the district attorney know right now. We have 2 fraudulent transactions done. Not only do we have it for you, Mr. Ainley, but we have it for Mrs. Ainley too.
I mean, you could check signatures even. I don't sign like
I
that.
don't believe that at all.
Okay, that's whatever. It is whatever. Not next day's gonna change it.
If I wouldn't have gotten these letters from these loan companies, from my mortgage company stating that these 5 lenders requested my payoff information, I would have never known that there was any type of fraudulent activity going on at all.
This is not fraudulent.
I'm looking at 22 CV 88 Rachel Ainley versus Timothy Ainley, your injunction request that you filled out. The signatures look almost identical,
Almost.
almost identical.
They're not me, I promise. Forging signatures, risking getting felonies, no, not worth it. I'd walk away from the house before I do that. I'm not stupid.
Almost identical. The signature Rachel Ainley on 22 CV 87, 22 CV 88, Rachel Ainley signature, almost identical.
Almost. It's not me.
You can't sign your name the exact same every way. I don't sign my name the exact same every way, Miss Ainley.
I didn't say that. But it wasn't me. I'm not an Ainley. I wouldn't sign Ainley.
It says Rachel Ainley. Because
Exactly.
you want to know what? Rachel Ainley owns the house, not Rachel Hess. So you have to sign it Rachel Ainley.
See, I don't know that. I didn't know that.
Please continue.
But I sent off a loan modification contract yesterday morning through FedEx. We signed them to keep the house afloat, keep from losing it. I'm still continuing to make the payments on the property. If not, I would lose everything, my whole life savings. Anytime my ex-wife has gotten any large amount or large sum of money, it's never spent on what it's supposed to. Bills, kids' bills first. Like I said, about 5 years ago, we were involved in a serious accident, her and I, in Hayward. She got a $40-something thousand settlement, never paid him payment on the house. And then, like I said, I got in some legal trouble back in May. And I was incarcerated in Polk County for a couple months. So I was totally ghosted out of everything. And when I was released and went into a sober living home, I started getting mail after I had my forwarding address to my home now. And I found out that it was going into foreclosure, and I caught it within like 4 or 5 days before it actually was foreclosed on. So I've done everything in my means. I can't do it anymore. I mean, you know, I can't keep paying $1,085 a month child support, a mortgage payment. Plus we have to pay $600 a month at Onyx Sober Living Place. It's an awesome Christian living home. I have to pay $600 a month there on top of gas and food. And I'm trying to get a steady work, and it's like, which this is coming through good too. But anyways, I just can't do it anymore financially. I mean, if it wasn't for God keeping me strong in my mind, I don't know. I would have lost it even worse than what I did back the last year and a half over this divorce. All
right.
I want is what I believe I deserve and what I have invested in the material things that's there now on the property and the home. And that's not even counting the things I've lost over the 17 years being married to her.
Okay, Miss Ainley, this is not your time for testimony. You will get time to testify and to provide your own evidence for the court. This is your time to provide or to ask questions of Mr. Ainley as it relates to his evidence and his testimony to the court. Do you have questions for Mr. Ainley?
Yes, I do.
You may begin.
When did you purchase this stuff? Because a lot of it, you never had when we were married.
And I'm going to state for the record by stuff, you're referring to what he has listed in.
Oh yeah,
his-
like a DeWalt cordless drill combo. $900. Really? Where'd this come from?
I purchased that when
I've got plenty of witnesses.
should have brought them with you.
Oh, I should have.
I purchased those, that DeWalt cordless skill saw drill, hammer drill set with a sawzall in it. I purchased that in Nashville, Tennessee when we moved down there when I started my remodeling business. We owned property down there at the time also. I believe I purchased that at a Lowe's building center, to my knowledge. Yes.
I have nothing more to say. It's just, I don't even know what to say.
All right, now, if you don't have any other questions for Mr. Ainley, this is your opportunity to provide your own testimony to the court and your own evidence to the court as it relates to this matter. You may
Do you
begin.
want a copy of what Commissioner said on the 10th of October?
I will have it in my file
Okay.
if that's what you're asking. I can take judicial notice of that. Let me get to,
Because that has what his lawyer added up on what I have to give him.
Ms. Ainley, I'm not hearing anything to contradict anything that Mr. Ainley has told me with regards to the property.
His property is there. Everything he left. Nobody has touched it.
Don't believe you. I don't believe
You
you.
could send somebody there.
I
It's there.
see pictures.
That was stuff that was put in his truck while he was there. That is not what I sent for him.
I can always do an order that he can go and retrieve property and with a dollar amount order. And if he retrieves property and it's not damaged, then that property, it diminishes the dollar amount that he gets. But I don't have any contradictory evidence. I don't have,
I don't
And
know
I
what I
told-
don't know what I can give you.
Ms. Ainley, I told you exactly what to give me on November 8th. I said, I need pictures. I need testimony. I need things. And what you needed to do then was you knew what he would be looking for. You knew what property was his or what he would be seeking.
And it's still his.
So you knew though, you have a cell phone, you have a camera, pictures. You could have brought pictures and said, look, judge, not damaged, still working. That's exactly what I told you to do. I told both of you I needed evidence. You needed to come here prepared. This was your day. This was it. This was the one and only day both of you would get. I was very clear with both of you, correct?
Yes, ma'am.
Very clear with both of you. This was your day to come prepared. Very clear. Without going out myself and taking the pictures and doing the case myself, I was very clear at what both of you needed to do. And you didn't come prepared to do that. Except you're coming and you're saying, it's all there, it's fine. But I'm hearing testimony that's saying it's not fine. I'm seeing pictures where it's not fine. And quite honestly, Miss Ainley, I hear testimony and I see things that show you're not credible. I believe you're not credible.
Okay.
I fully believe you forged his name.
No, ma'am.
I fully believe you forged
And
his
how
name.
would I do it?
Hi, pen, hi, paper. Let's write Tim Ainley.
No.
I'm not blind. I can see.
Well,
And
maybe
I've
we should have
taken
someone look at it then.
judicial notice. I've been doing this job a long time. I look at your signature on 2 documents where
Yes.
you've signed.
Look at his.
I have. It's
I
not
don't-
his
It's
signature.
not mine.
This is your signature,
No.
Rachel
Can
Ainley.
you call Katie? I didn't sign.
Then you were not looking to sell this property because this is what it took to sell the
I
property.
can't sign. You told me we couldn't sign
Sign what?
the papers yet.
You didn't sign the papers. This was to try and get a payoff, to try and get the offer.
I've made
what
no
you
attempt to
got.
get payoff. They do. The company does. I make no attempt. I have not made any attempts.
Need payoff, please.
See, it's sincerely Katie, not Rachel. And Katie is wherever that is.
Miss Ainley, the more you talk, the more you're digging your hole.
Okay, well, I'm not gonna say anything. I'm telling you.
I strongly encourage you not to, because this is all taken down
Okay,
and this is a transcript and the district attorney can get this transcript.
okay, that's fine. Because I don't have anything to hide. I don't. I would have plenty of witnesses, but you didn't want kids here.
I said, bring witnesses.
I wouldn't put my kids through it.
And I think that that is the best thing that you could do
That's who I had.
as a mother. Because quite honestly, that was a terrible,
It was.
awful thing that happened at that other
So by
hearing.
not bringing them, I have no credibility. So just order what you're gonna, order what you're gonna. I just want it done. I want,
If either of you put your children in the middle, you are awful parents.
that's why they're not here. That's why I have no witnesses. Because all I had was my kids.
No, you don't. Miss Ainley,
Yes, it was. It was.
you can stop crying because tears,
I'm not crying because of that.
again,
You're
telephone.
not listening.
You're not listening. Stop crying. Stop that. Telephone pictures say 1,000 words. Stop it. This
order
boo-hoo,
what you're gonna-
cry means nothing.
Okay.
See? No tears. Nothing.
Oh, I got none now.
I know, because they're not real.
Oh, yeah.
I don't
Okay.
fall for those
Okay.
tears. So now, do you have any
No.
proof or any evidence? Because quite honestly, right now, there's nothing in your favor.
I guess not.
Because I fully believe, Mr. Ainley, I truly do believe you walked out with nothing. I believe you walked out, quite honestly, with the clothes on your back. And with what you said, you had a couple shirts, a couple pair of underwear, a couple pair of socks. You had nothing. Quite honestly, gonna be blunt. You were quite, not so smart. You've never been smart with this lady. You've never been smart with this lady.
I agree.
You've let her control you and take everything from you. Because when you are here and you came here with your divorce, you came with this exhibit of personal property that you wanted to retrieve, and it's bare bones. It's not really that enforceable. You should have went that day or very soon after that day to retrieve this personal property. And then when you went back with your attorney in front of commissioner to retrieve your property, and it's very clear in that hearing that commissioner said 2 dates and 2 sets of times to go retrieve your personal property, which Miss Ainley said today, I didn't know, which was a lie, because she knew, because it's very clearly there in the minutes.
Ma'am, I said it wrong. I didn't know he would show up because he was set to come before and he didn't show. He was set to come in June and didn't show up.
Well, he had his attorney, he paid his attorney, they went to a contempt hearing, they got 2 specific dates with 2 very specific times to go show up. And you were instructed not to be on that property, not to be on that residence from 2 to 4 p.m. on September 30th and 2 to 4 p.m. on October 1st. Very 2 specific times, 2 hours
I'm
on
guilty
2
of it
days.
then. I'm sorry.
Stop talking. 2 hours on 2 days where you could have just went to Dairy Queen. You could have went to the dairy. You could have went driving. You could have went anywhere for 2 hours those 2 days, and you didn't.
I agree.
So Mr. Ainley, you had these 2 specific times to go get this property, and you went, and she was there, and it set your mind aside, or you lost all track of what you were doing. But you needed to get your property that day, because that's when commissioner said, get your property. And you didn't pick anything up that day. And then from September 28th, 2023, when you were supposed to get your property, even though you were supposed to get your property that day, she was not supposed to be there. Both of you didn't do what you were told to do from the commissioner. Neither of you did what you were supposed to do. Neither of you do what you're supposed to do. It's a history with both of you. Neither of you do what you're supposed to do. You should have went back. You should have gotten it a whole lot sooner from the date of divorce, because the date of divorce was way back, March 6, 2023, and it's now November 21st, 2024. There's absolutely no guarantee that anything is there and anything is in its proper order or condition, because it makes it very hard when we're here in November 21st, 2024, when this divorce was March of 2023. And I can't go back and say, okay, now what tools did you really have during the marriage? You understand?
Yes, ma'am.
I wish I could, because I do find you more credible, Mr. Ainley. Although in this divorce, it's hard to find credibility. And I'm awarding $15,000 because I do believe that is a penalty. Because I do fully believe that Ms. Ainley fraudulently signed his name. So there is a total of $64,368.71.
64,000 what?
$64,368.71. That is to be paid to Mr. Ainley from the proceeds of the sale of the home. If the home is not to be sold, if it's not sold tomorrow as expected, then the court is going to order that the home is going to be remitted over to Mr. Ainley for ownership instead of Miss Ainley.
Your Honor, the latest to close was December 30th.
Thought it was gonna close tomorrow.
We were supposed to, but he refused.
Well, then it can close.
If they're willing now.
If not, then I'm ordering that, if it doesn't close, then ownership of the home turns over to Mr.
How do I
Ainley.
get, how is that fair to me and the kids?
How is it fair? Because I fully believe you signed
I
his
did
name.
not.
I
What do I
fully
have to do to
believe,
prove it?
Ms. Ainley, I fully believe that you have destroyed his property,
I
that
did
you
not.
have burned his property, that you have.
This is the hammer. The judge isn't just awarding money, she's punishing behavior. That $15,000 isn't just compensation, it's a penalty for dishonesty. And the ultimatum is brutal: sell the house or lose it. Courts don't reward chaos, they shut it down hard.
Sold his property, that you have thrown away his property, that you have done everything to keep him from having his property, that I believe that you have done everything.
Well, if somebody goes to the house, you'll see it's
And
not
you have
true.
been totally
Okay,
vengeful.
Well,
Now,
so you think, yep.
he can go and retrieve his property. And if all, Mr. Ainley, you have the ability to go to the property. You're still at the property, Miss Ainley?
I won't be.
When? You're out of the property? You moved out of the property?
I will be tomorrow.
You've moved out of the property
I
tomorrow?
won't stay there.
So are you moving out of the
Yes, I
property
am.
and you're living somewhere else?
I'm going to, yes.
Okay,
I don't have a choice.
all right. So you can go to the property tomorrow and retrieve all of your property.
Time.
You can look all day. She's not gonna be there anymore.
What
And
if it's
apparently
locked?
the house is going to be sold.
What if it's locked up?
Well, you would have the ability to, you would have the ability to have a locksmith come and go into the property.
Your Honor, what if he takes more than what's his?
He is ordered to only take his property, and that would be anything that is on the list that you have. He is not to remove anything else but anything on that
happen.
list.
I will make sure I have a witness with me and take pictures, ma'am.
All right, so you can go tomorrow and you have all day if you want.
One more question, Your Honor. The amount that I was awarded, the $64,368.71, if she closes on that property, is that mortgage company that's buying the house or whatever, they have to cut me a check for that
Yes,
amount
they do.
before I can
Yes,
close on
they
it?
have to cut you a check for that amount.
Yes, ma'am.
And so, Miss Ainley, it's not going to close tomorrow now?
I have no idea.
Well, if it doesn't close, then again, the court is awarding the home to Mr. Ainley.
As of tomorrow? I have 1 day?
It was supposed to close tomorrow. That is why
Yes,
this
but
court,
he refused. He told them no.
but here's the thing,
But that's why they went to December.
Ms. Ainley, and the court specifically held this hearing today.
I
So
know.
it can close
I know.
tomorrow.
I know.
Did you not recall that I had a
Yes, ma'am.
mandatory
Yes.
education course that I had to have today?
Yes, but I don't have control over them. I don't.
You had it set to close
Yes.
today.
I had it set to close tomorrow.
If it closes tomorrow, Your Honor, I'll sign whatever needs to sign. That's not going to slow up any
You
closing.
can contact them and the court will prepare an order here today and I will have it done here shortly.
Yes, ma'am.
And then it can be signed and Mr. Ainley, you can come and retrieve it by 4:30 PM and you can make sure that the company has it.
Yes, ma'am.
All right.
Yes.
All right. Thank you. Then we are adjourned.
Thank you.